The only way at that time that they could pass them under what was called reconciliation, because it passed in the Senate by 1 vote, okay, which was Dick Cheney at the time. And in order to avoid what's called a filibuster, we've heard about, you know, the filibusters where basically the Senate can kind of not even consider something when not enough people vote to even bring it up for a vote. In order to pass it through what's called reconciliation, it had to be projected to not add, it actually had to be projected to reduce the deficit as opposed to add to the deficit. And the only way they could even fudge the numbers was having it expire this year. Otherwise, they could have had these tax cuts made permanent at that time, including the repeal of the estate tax. But they couldn't do it under the rules that were in place, so they had to have them expire this year. And so that's what we're faced with.
So a couple of questions. So do you have to change the deed of trust in your house once you establish the deed of trust?
No, once you establish a living trust, we will do a grant deed transferring the house into the trust, but the deed of trust that you have with your lender, that stays with it, that doesn't change.
Okay.
And for the personal residence, you don't even need to notify your lender that you have a living trust.
Okay.
If you have secondary properties, theoretically you should notify the lender, but if it's a living trust, they're going to accept it. They don't really have much of a choice.
And what is the association of life insurance and the living trust?
Okay, life insurance is a good tool to use for a number of reasons, but in the estate planning context, it's something that we use, or we recommend the client uses, I should say, to come up with a source of cash to pay estate taxes. So if you have an estate that would generate estate taxes at death, but maybe it's all in real estate, okay, and you know the person dies, if there's no cash to pay it, the children are going to be in a position of having to sell off assets to pay the estate tax, which is due 9 months after death, okay? With a life insurance trust, you can have this life insurance policy set aside that can then provide cash that can be used to pay the estate taxes. And it doesn't pay them directly, you have to exchange it with property from the trust, but I mean, that's just, for our purposes of this discussion, it's used to pay estate taxes. Okay, I mean, that's the main thing about that. Okay.
A friend of mine passed away about a week ago, doesn't have any family. He does have some assets.
Okay.
What happens to his estate?
Okay. So, well, that's actually an interesting question, because if there is no immediate family that's willing to come forward, either a friend can do it, or what's going to happen ultimately is if he owed money to people, one of his creditors is going to file a probate action to set up the probate, so that someone then will be appointed to, again, collect the estate, pay the debts, and that's why the creditor would want to do it, because they want to get paid, obviously. But ultimately, what's going to happen with the estate is California has a whole chart of who gets what when you die. So if you don't have a will, you don't have a trust, you don't have any instructions, there's this chart that says, okay, well, if you're married, your spouse gets it. If you're married and you have kids, it gets split. If there's no spouse and children, it goes to, you know, grandparents and grandchildren, and so on and so on and so on. So ultimately, you know, it could go to, I think it's like the third cousin 5 times removed. I mean, so it could be me or you or anybody, you know, for that matter. But if none of those people can be found, and again, I mean, it's a chart, literally there's about 30 or 40 different people that could potentially inherit from this person. I mean, ultimately, it could even be from, it can even go to, if he had a deceased spouse, it could go to her family or his family before, ultimately, if no one can be found anywhere on this chart, then the state becomes entitled to. Okay? But chances are there's going to be someone that fits the definition. Because, I mean, again, it literally goes to like third cousin 5 times removed. I mean, and that could be anybody. Okay, so in your case, if you're married, if anything's community property, it would automatically go to your husband. Okay? So anything jointly held, for example. If you had anything that you had prior to marriage that you kept separate, or that you have inherited from maybe your parents that you've kept separate, that will then be split between your husband and your children. If you have just one child, it's 50-50, okay? And then if it's, you have more than one, then it would be 1/3 to your spouse, 2/3 to your kids. But anything joint is gonna go to your husband. It's governed by the laws of that state. So that's another benefit of a living trust, is if you have property out of state, in particular real property, you can put that property in the trust, and the trust is gonna govern it, okay? Whereas if you don't have a trust, and you have real property here, and let's say you have real property in Texas, okay, as an example, when you die, not only do you need to file a probate in California, then you're gonna have to file what's called an ancillary proceeding in Texas to probate the real property in Texas. If it's outside the US, the living trust isn't gonna help at all. You need to deal with whatever the law is of that country. I mean, I've had clients that have, property in England, India, etc., Canada, and, I just tell them that you need to, if you're gonna go back anytime in the future, you need to go find an attorney there and set up whatever you need to set up there, because what I do is not going to affect that property. Yes, if you have property in another state and you put it in your living trust and you live in California, the trust itself will be governed by the laws of California. Now, when you transfer it in the other state, you need to follow whatever the rules are there as far as what forms you need to file with the county and that type of thing. But it will be in your trust and will be governed by California. And so again, that's another good benefit of a living trust, is that you can have property from outside the state, put it in the trust, and not have to go through doing all these different probate proceedings and that type of thing.
I have a friend whose house got stolen. Possessions in his house got stolen, but he put everything in the living trust. What's his next step? I mean,
Call the police.
okay, then how about the living trust thing? He put everything in a living trust.
Well, I mean, in that situation, I mean, the trust has no bearing really over, he had his stuff stolen, he needs to, file a police report, but, obviously if there's things that he said, this person's getting this particular item or whatever, he may want to change his trust to reflect the fact that that item's no longer around anymore. But other than that, there's not much to do. Okay, well, for most people in California, the main benefit of a trust is actually to avoid probate. It's not to save in taxes. For a married couple, it can save taxes, okay? During your lifetime, the benefit is that you would have dealt with your financial institutions ahead of time, because they typically would have a copy of your trust, so that they know that if something happens to you, you've had a stroke or something, they know who's going to take over, and it's going to be a lot easier than if you were doing it with the power of attorney. But, there's not really a lot of other benefits to you, but there's no disadvantages of doing it either. Now, one of the things that I do is elder law, and in that context, with dealing with people that are planning for incapacity, there are some benefits that a properly drafted trust and power of attorney would have. The way Medi-Cal works, if you need skilled care, is that it looks at your assets, and certain things are going to be considered exempt. And that means, and it's talked about in the booklet, so, you can refer to the booklet. But exempt assets, as far as Medi-Cal are concerned, are things that they don't count in determining if you're eligible for benefits, okay? And I'm talking about for skilled nursing care at this point. Examples of exempt assets would be your house, okay? If you're the medical applicant, your IRA is an exempt asset as long as you're taking distributions from it. If you're married, then your spouse's IRA is a completely exempt asset. Medi-Cal does not count it in determining your eligibility for Medi-Cal. You can have a car, personal effects, you can have term life insurance, burial arrangements, there's others, but I mean, those are the main ones, okay? Then beyond that, there's what are called non-exempt assets, and those are what you can't have any more than that, what they list, in order to qualify for Medi-Cal, okay? For the Medi-Cal applicant, you can have $2,000 of non-exempt assets, okay? Which is not a lot, obviously. If you're married, your spouse can have $109,560 of non-exempt assets. So let's just say $110,000, okay? So a married couple total can have $112,000 approximately of non-exempt assets and still have the one spouse qualify for Medi-Cal, okay? But what Medi-Cal is going to require is that